How to survive a debt collection lawsuit, the first move that counts. 1. Getting served. Picture this. You're at home. A knock at the door. The sheriff or process server hands you papers. Surprise, you've been sued. Not exactly the dinner delivery you wanted. So what does that actually mean? It means the countdown clock just started. Those papers are not junk mail. They're the lawsuit and the summons, and they control everything that happens next. Ignore them and the court will assume you agree with everything the debt collector wrote. That is how default judgments happen. Translation: you lose automatically, plus attorney fees, plus interest, plus headaches. Footnote: getting served is the legal way a lawsuit officially begins, and the summons tells you how many days you have to respond. 2. The deadline. Every summons has a number on it. 20 days in some states. 30 in others. A few give you 14. The clock starts the day the papers hit your hand, not the date stamped on the top of the complaint. People mix this up all the time. Mark it on your calendar. Set reminders. Then give yourself a 5-day early warning just to be safe. Miss that deadline and the collector gets everything they asked for. Think of it like missing the buzzer in a basketball game. You don't get overtime, you just lose. Footnote: courts enforce filing deadlines strictly. 1 day late can be fatal to your defense. 3. Filing an answer. So what do? You answer. Literally. The document is called an answer. You deny what's wrong, admit what's true, and raise any defenses you have. You file it with the court before the deadline, and you send a copy to the creditor's lawyer. Do this and you're already ahead of 95% of people sued. Why? Because most never respond. They freeze, ignore it, or hope it goes away. Spoiler: it doesn't. Debt collectors count on silence. Your answer ruins that plan. Footnote: filing an answer prevents an automatic default judgment and forces the creditor to actually prove their case. 4. Settlement options. Not everyone wants to fight a full lawsuit. That's fine. You can talk settlement with the collector's lawyer. The rules of evidence protect you here. Offers to settle cannot be used against you in court. So you can negotiate without handing them a free win. Sometimes early deals save time, money, and stress. Worst case, they say no. Best case, you resolve it on terms you can live with. Footnote: settlement talks are shielded under rules of evidence, which encourage negotiation without legal risk. 5. The takeaway. File the answer on time. Period. That single step gives you leverage, control, and a fighting chance. Remember, more than 95% of these cases go unanswered. Be the exception. Put the date in your phone. Circle it on your wall calendar. Tattoo it on your brain if you have to. Answer, then explore settlement or defense options. You'll sleep better knowing you did not hand the other side an automatic win. Footnote: responding on time shifts the case from an automatic loss to a real contest.